All right. We are supposed to be live. Hello, everyone who is following us, and thank you guys who came here on location in Turku. My name is Johan Nyman. I do represent the association Intact Finland, or in local languages, Intact RF EHJA RY. This presentation that I will be giving is an overview of policy and legislative developments during the years 2008 to 2022. This presentation has earlier been given in local languages, in Swedish and English, and the recordings for those are found under this live feed or recording. Så den svenska inspelningen finns tillgänglig i en länk under den här. Ja vastaavasti suomenkielinen tallenne löytyy tämän englanninkielisen tallenteen alla. I will switch screens here to make sure that the presentation is seen a bit bigger. You will in this presentation see some text in local languages, Finnish and Swedish, as the presentation is based on the local presentations. But I will explain in English as we go along. Right. So, genital autonomy. First, some words about the topic itself and the term, the usage. What is it? Genital autonomy is the right to self-determination over one's own bodily integrity, when it comes to non-medical cutting of the person's genital organs, regardless of the person's gender. And what is then genital autonomy for children? That is work for fostering the protection of children from non-medical genital cutting, girls, boys, and intersex children. I will again switch screen for the online participants, so I will hide my own window for a moment. The approach for this fostering work is based on bioethicist Brian Earp, among others, who takes a holistic approach to this topic. Right before our first presentation this autumn, he said in an online discussion like this: in general, the position I defend is one of genital autonomy. That means protecting people from non-voluntary genital modifications that they don't want, didn't request, or definitely cannot consent to, while preserving and allowing the choice of relatively more mature and autonomous persons to decide whether or how they may want their bodies to be modified under conditions of informed consent. And this forms part of a longer online discussion that he had. So this was an excerpt from that one. It bears the title Protecting Children or Policing Gender from September. And there's a link to it as well. Brian Earp is a senior research fellow in moral psychology at University of Oxford, and he has formerly also been affiliated to Yale University and the Hastings Center there. After that, I will start by showing you two video clips. I written like this: they stood up and addressed the elders and highlighted the need for a change. Let's watch the first one. I will again switch windows. The first one that you will see is Nice Lengete from Kenya. She won the BBC Outlook Inspiration Awards in 2018 for her work on prevention work on female genital mutilation.
We lost a girl because of circumcision. So I saw death in this community. I saw girls as young as 7, as young as 8, when their dreams are taken away. After circumcision, they are married off at the age of 10, 12. And I knew that when I agreed to undergo the cut, I'll not be able to come to school. I started with helping girls escape, but I thought this was not enough because they go back to their family, they start fights, they run away. Then where do I take them? So, we kept on fighting with the community, and that is when I realized we need to find a way of talking to them. It was not easy because a woman is not supposed to talk in front of men in this community. But I knew fighting female genital mutilation, it takes time. I wanted to use education as a way of convincing them that we really need to invest in girls' education the same way we are investing in boys' education. So we said in the whole process of female genital mutilation, what is harmful is just the cut. So let us do away with the cut, and all the other rituals that are performed during circumcision time, let us remain with it, because morally we need to feel like we are still owning our culture. That is good. And that way, for the last 7 years, we've been able to reach over 15,000 girls who are now women without the cut, and they're in school. I think with books and pens, when we invest in girls' education, they will be able to become professors, doctors, and teachers, journalists, or anything they want to become. And that is my hope, that all of them will be able to get education.
So that was Nice Lengete, who addressed the elders, the Maasai elders of Mount Kilimanjaro. I will also play another clip where another person addresses the elders, but these elders are not at Mount Kilimanjaro, and they are not having traditional Maasai dressing. Instead, these elders are wearing Western suit and tie, and they are in Iceland, in Reykjavik in the Nordic house. I will switch to the other video clip and we shall see it. Let me do some preparations here. Yeah, so here we see Evan Roman, and for you that are here, you see that he's actually present here also. I will play the clip in full screen mode, so also you that are on distance can see it there.
So 4 people have entered their names on the speakers list, and so I'll just call them up, and the first one is Evan Roman.
Do I come up here? Thank you for having me today. I'll wait for him. I am from the United States. I'm from a Jewish family. I was raised Jewish. And I'm here today to support the bill. I have seen friends, colleagues, people I've known. I've heard so many stories as an activist against circumcision in the United States, where it's very common. Stories of lifelong pain, lifelong depression, suicide, lifelong loss of sexual function due to circumcision that they did not consent to as a child. I believe that forced body modifications are for consenting adults only. I am very thankful to be here and be allowed to speak. Iceland is looked up to by the whole world as a country that represents the top of human rights and democracy. It leads the world in this, and the rest of the world is watching you today. And my question for the members of the Althingi and for the people here today who spoke, what do you say to the people like me who feel violated by circumcision done to them as a child? What do you say to them? Thank you very much.
Yeah, so what I wanted to depict with these two presentations was two persons that stood up and addressed the elders, and whether we consider them differently given the two different contexts that they were. And this may then form a basis on continuing on to the actual topic, which is the legislative and political proceedings. But one more thing before getting there. Which terms should we use, when and for whom? Should we use circumcision or should we use genital mutilation? It is not the way we see it, based on those scholars that we base this work on. We do not see it as determined by sex or gender, but instead that each individual himself or herself decides what to call it. Each individual decides how to relate to the cutting that was done to them as a child. Some people are proud and happy. Others are indifferent, do not experience any downside from it. But then others again are sad or angry or dejected and experience it as an integrity violation, which might limit their well-being and daily life. It is also, this holds regardless of sex or gender. So it is also the person, each individual themselves, who decides what to call the procedure that was done to them. Also, this holds regardless of sex and gender. Now, I think we are ready to move on to the actual timeline of legislative and political proceedings. I wrote that we will start from 2008, but we will do a small step backwards here to 1995. Then the Criminal Code of Finland had this chapter 1 established on homicide and bodily injury, and the two sections, section 5 on assault and section 6 on aggravated assault. And it's actually these 2 points, these 2 sections that form the basis of the legislation for for genital autonomy in Finland. The Criminal Code, Chapter 21, paragraphs 5 and 6. They form the basis for this, and they are gender neutral. Boys and girls, intersex children, all alike. But their application differs based on the gender. And this is what we will take a look on now, given this timeline. I will show you some examples on how it differs, how the application of one and the same legislation that is uniform for all children regardless of gender is applied differently when it comes to children of different genders. THL, or THL in English, the Institute for Health and Welfare in Finland, has information on female genital mutilation. There it says female genital mutilation is a crime. It is punishable under the criminal code of Finland as assault or aggravated assault. Paragraph 5 and paragraph 6 that we were just looking at. THL, they also have an instruction page regarding boys. The same legislation, but the application is a different one, saying, while non-medical male circumcision is not currently prohibited under Finland's legislation, and so on, it is considered to violate the child's bodily integrity and self-determination. Same law, same legislation, different application. Why is it so that their application differs based on gender? Why this difference? When it comes, here is one more page from THL when it comes to boys. Not only do they apply it here in a sense that they say it is not currently prohibited, but they also provide an instruction on how it should be carried out. Instructions from the Ministry of Social Affairs and Health, and also a guide for parents. Now, in many senses, it is good with a guide. If it's being done anyway, then supposedly a guide could be good. And the guide also says, as a first thing in it, that this procedure is not necessary to be performed on your boys. It starts off with that. Then it goes on and says how it should be done, which in no way is the case when it comes to girls. There it is said clearly that this is not to be done at all, and it is prohibited. And now we can start the actual timeline that starts with 2008. I will start then with the Supreme Court of Finland that had a precedent in 2008. A parent had his 4-year and 6-month-old son circumcised by a person, and the parent was the sole custodian of the child, and on the grounds presented by the Supreme Court, it dismissed the charges against the sole custodian parent. One of the grounds were that given that it was a sole custodian, it was not necessary to ask any consent from the other parent because there was none that was a custodian. So in that sense, all of the parents, gave consent to the procedure. What was said in the decision by the Supreme Court was that even if it may cause some pain to the boy, there are no health-related or other disadvantages to the boy. Now here, I have looked a bit into this and talked to some lawyers that have good insights into how the Supreme Court works, and I tried to find out what could possibly the information basis have been that the High Court or the Supreme Court use in order to form their decision, but it is not public information. What is clear, though, is that there are some later findings that the Supreme Court in 2008 did not have access to. And then the interesting question is, would they at that time had access to those findings? Would they then have decided differently in the decision which became a precedent, and which became a precedent also for some other precedents that we will look upon later. Namely, in 2013, researchers Torup and Ifaui state that out of performed ritual circumcisions in a clinical setting, 5.1% of those led to complications that require corrective measures or operations. In addition to that, there are 2% more of complications that do not require corrective surgery, but that were nevertheless complications. And that forms a total of 7.1% complications. So, and these were circumcisions done. This study was done on circumcisions that were done in the Danish National Hospital, Rigshospitalet. So it was the top-notch clinical setting of Denmark, and still there were 7.1% complications. So when we put this in contrast to the Supreme Court precedent, where it says, even if it may cause some pain to the boy, there are no health-related or other disadvantages to the boy, then we might ask ourselves, had the High Court known what was 5 years later presented in this study, would they then have done another decision? Then another study, this is the Danish study Sexus from 2019. I will switch screen a bit again. There we go. And in this study, which was on sexuality, it was a big overall study on sexuality, but it also had a section that concerns circumcision. One question that was presented, actually this question was presented only to men, not to women. It concerned satisfaction with circumcision status. How satisfied are you with being circumcised? How satisfied are you with not being circumcised? The first question was presented to 2001 male respondents that had informed that they were circumcised or had been circumcised. The second question was presented to more than 27,000 male respondents that had informed that they were not circumcised. They had not been circumcised. The outcome of the questions was that 5.5% of those that were circumcised of religious reasons, and 7.4% of those that were circumcised of medical reason, of those circumcised men that were asked about this, were dissatisfied that circumcision had been done on them. This is from what is to my knowledge, the biggest population survey in the world on sexuality, Sexus in Denmark, by Morten Frisch et al. From 2019. So if we relate this then to what the Supreme Court said, we can also see that when it comes to how the person himself feels about this, it is not all clear that this is in the best interest of the child. Furthermore, the Supreme Court stated this: in reality, circumcision of girls is genital mutilation, and it is thus a far more severe breach on personal integrity than that of boys. Female circumcision is not reasonably comparable to male circumcision in a criminal sense. Here, it might also be the case that the Supreme Court did not have access to what Brian Earp et al. Later started to show in their findings, in their scientific papers that consent goes before gender, that gender does not decide the degree of severity in different types of genital cutting procedures. Also, it is being shed light on that granted and ensured bodily integrity for both parents, meaning that both parents have their own whole body intact, including their genitals. That is what provides the best basis for ensuring genital autonomy for the child. All of that seems to have been pieces of information that was not known from elsewhere by the Supreme Court, where they found when they formed their decision in the 2008 matter. So I will try to switch the screen again a bit. There we go. So we go on. Why this difference? We jump to the year 2015, and what happened there is that the Finnish government came out with the degree of putting the Istanbul Convention to formalize it in Finnish legislation. What this means is that also the part of the Istanbul Convention that speaks about female genital mutilation now became formalized in Finnish legislation. This could potentially, as I see it, also have contributed to why the one and the same criminal code of the Finnish legislation is considered differently when it comes to girls and boys. The Istanbul Convention from 2011 is the Council of Europe Convention on Preventing and Combating Violence Against Women and Domestic Violence. And Article 38 speaks about female genital mutilation. And it says there about which procedures, it lists some procedures that are to be criminalized. Moving on to 2016, where two new Supreme Court precedents came out. The Supreme Court adopted two decisions that complement a previous one, the one from 2008 that I already showed you. Two new Supreme Court precedents, number 24. In that case, the parents and the circumciser were freed, were acquitted. And then the case number 25, where the father was sentenced and the circumciser was acquitted, did not get a sentence. The reasoning for this was, in the second case, that the child had both his father and his mother as custodians, but the father had the procedure done without the mother's consent. And then the Supreme Court counted it like that both parents had not consented, thus the father who had it done was sentenced. The circumciser was not. Here's some reasoning in Finnish, and I will really quickly summarize it. Actually, I would say I already did summarize most of it. In the first case, both parents consented. In the second case, the Finnish mother did not consent, and the Nigerian father had it done to the child, and because the mother did not consent, the father was then sentenced. The procedure would have needed both parents' consent. What the Supreme Court said there also was that it is lackful that Finland does not have a clear legislation on this. So I would say that that is actually very valuable that the Supreme Court strongly points out the lack for specific legislation of this in Finland. That same year, 2016, the Finnish broadcasting company Yle and the Swedish-speaking division of it, Yle Svenska, in their investigating program Spotlight, made one episode about circumcision of boys. In that episode, they interviewed also the person who performed the circumcision in this case, who was not sentenced by the Supreme Court. This program had quite a short lifespan, so to speak. It was not being kept open for long before the validity period where you could view it closed. But we approached them, Yle, and asked, could you open it again? And they actually did. So now it is open again, and it can be seen. It is called Med kniven på förhuden, or in English, with the knife on the foreskin. Some things that the Supreme Court said in this case, what I was already touching upon, is that it is unsatisfactory that the justification of a circumcision performed on other than medical grounds and the conditions for the criminal liability of the person who performed such a procedure have to be assessed on the basis of case-specific and discretionary aspects when it comes to the child's interest. Furthermore, individual case-by-case court decisions cannot be used to comprehensively manage this issue, but instead a proper weighing based on the overall interest of the child is only possible by a legislative procedure based on proper preparation. That is it. The other case, there it is said that male children are also circumcised for medical reasons. And also the circumcisions in this case have been in the best interest of the child. Now, as we saw already from the Census 2019 population survey on sexuality, quite a noteworthy percentage of the male respondents did not find it to have been in their best interest that it was done to them, even when it was done on non-medical religious reasons. We move on from 2016 to 2018. Then a citizens' initiative in Finland is initiated on banning female genital mutilation. It got the needed 50,000 signatures, so it was passed on to the parliament. That same year, 2018, also a citizens' initiative was initiated in Denmark. Now, this initiative was very special in the sense that already the title is Introduction of 18 years minimum age for circumcision of healthy children. It always speaks about children, not in one place in this initiative. They specify the gender or sex of the child. It's not boy or girl or intersex, it's only children. That initiative follows the same approach that we do, namely to consider this issue holistically, regardless of the gender of the child. This initiative, for those that speak Scandinavian languages, is publicly available. And if you speak Finnish, there exists also a professionally made translation into Finnish of this initiative, as it is something of an example of best practices when it comes to this issue. Then in 2019, the Finnish Citizens Initiative on female genital mutilation is received by the parliament and handed in to the law committee in September 2019. We see here Ujuni Ahmed, who is handing over it together with Annette Gottoni from World Vision Finland, and also Jukka Kurttila from Marimekko, who was collaborating on the marketing campaign for this initiative. It is taken into the legal committee or law committee. Expert opinions are collected. Hearings are organized for the called experts. By Brian Earp, as a bioethical expert within this topic, was actually proposed as one of the experts. He was not called, and the law committee does not publish their discussions. They only publish the protocols of their formal decisions, like, for example, who they ended up calling. They do not publish information on who they did not end up calling. But I've spoken to the law committee secretary afterwards, and she confirmed that they did discuss whether to call Brian Earp. Now, this was in 2019, so it was before the COVID. He would have been prepared to come. At that time, he was not in Oxford yet, but in the US, Yale University. Nevertheless, he would have been prepared to come had he been called as an expert. He was not at that point. We will come back to that a bit later, but still the same year, 2019, something that I find very special happened. STM, which is the Finnish Ministry of Social Affairs and Health, they published an action plan for children. It's called Non-Violent Childhoods, an action plan for the prevention of violence against children, 2020 to 2025. In that plan, there is chapters on prevention work for non-medical genital cutting of children, when it comes to girls, when it comes to boys, and when it comes to intersex children. Now, they are not all alike. They are formed and worded differently. The content of these chapters differ between them, but I will here shed some light on the one that concerns boys, non-medical circumcision of boys, objectives and actions for 2020 to 2025. And the one concrete action that is stated here is discussion will be started about an age limit, that is, postponing circumcision until the boy can participate in making the decision himself. And there are also concrete indicators for this, such as the age when the circumcision is performed will be monitored up until 2025. And also, this might not be seen very well for the distance participants maybe, but I will read the second indicator here. Statistics on non-medical circumcision performed on underage boys at university hospitals 2020 to 2025. So the age will be monitored and statistics will be collected. These are concrete indicators. Also, in the column there of justification, we have an interesting thing, which is the government program. At that time, the prime minister was Antti Rinne, and in his government program for 2019, it's a reference to that program and to a specific point in that program. Namely, the one point that says, the government will ensure sufficient resources for the work against genital mutilation. Now, this is a bit interesting because what happened here was this, that the English translation of the government program on this specific point was wrongful at first, because it was an extra word had been added. It said, the government will ensure sufficient resources for the work against female genital mutilation. So the translator had, by himself or herself, added the word female there. In the original languages, this reference to the female gender does not exist. And upon inquiry from our direction, the initial inquiry came actually from our brother or sister association in Denmark, Intec Denmark. We helped to pass the inquiry on to the government, and they realized that, oh, that was actually an error, and they erased the word female from the English translation of the program. This point, gender-neutral point, genital mutilation, when it comes to the work for the prevention work for that, was also taken on when in the next government program, when it changed from, the minister changed from Antti Rinne to Sanna Marin. Then we go on to the next year, 2020, and we go back to the FGM initiative that was initiated in 2018, taken into Parliament and Law Committee in 2019. It was remitted back to Parliament in October 2020 with two reservations, and there were a plenary discussion and votation on it. And I will see if, now this is in Swedish, but I will explain what it is about. There were two reservations and proposals to the draft done by the Law Committee on how the legislative work for FGM prevention work should proceed. Namely, the Law Committee concentrated mainly on girls, but they had made quite a big paragraph, quite a long paragraph that mentioned boys also. The first reservation and proposal was to erase every mention of boys within the Law Committee's paper. This reservation was made by Antero Laukkanen from the Christian Democrats and Eva Biaudet from the Swedish People's Party in Finland. But then there was another reservation and proposal where it said that we propose that circumcision of boys should be lifted up so that it, in practice, gets the same status as when it comes to girls, when it comes to protecting them from this procedure, also in legislation. These proposals were then voted in the plenary session in the parliament. And what is said here in Swedish is that in the first votation, the Christian Democrat and Swedish People Party Law Committee delegates proposal that each and every mention of boys should be erased, won 109 votes by the parliamentarians. It was put against the second votation, the second proposal, reservation, that every child should in the end get an equal protection in law. So once again, in this votation, 109 parliamentarians were of the opinion that each and every mention of boys should be erased. Only 34 voted for the other one, saying that all children should have equal protection in law. 56 seats were empty, 56 votes were empty, or the parliamentarian was absent from that session. In the second votation, however, the winning one, that all mentions of boys should be erased, was then put against the law committee's original draft that had, as I said, quite a lengthy mention of boys, even if not as much as girls. In the second votation, the law committee's original draft won, and that is what was passed on then further. Which means that what made then its way to the government, I've written there, remitted to the government. What made its way to the government was the original draft, which concentrated mostly on girls, but also had quite a long chapter on boys. It was remitted to the government. Then a work group was initiated in May 2021. I will switch screens a bit here again. For planning legislative proceedings on FGM prohibition. Its mandate was originally set until this summer, but then it was prolonged to November 2022. So that would actually be today that its mandate then would end. But now I saw on the government's webpage that it was prolonged again until end of December. I also got a confirmation from the chairwoman in the work group that they will not give any details before the mandate of the group has officially ended. Only then they will present their findings and possibly give access to the protocols and which experts they called and what their statements were and so on. Now we are approaching the end. What I very briefly could possibly mention here is how the political parties, some of them, what they have been doing on the topic of children's genital autonomy. I do not have an extensive information of that, but what I can say, for example, is that the Green Party has in its party program a gender neutral aim concerning all children to work protectively for them when it comes to genital cutting. And I believe they have had so already in several consecutive party program periods of theirs. Then the Social Democrats, their youth organization a few years ago had, they also made a statement that boys should be included in those that are protected from non-medical genital cutting. Also, the coalition party, Kokoomus, a few years ago had an initiative and a motion taken all the way up to their yearly party congress on protecting boys. And I believe it was actually initiated by one of its youth associations here in the Turku region, Auranmaan Kokoomusnuoret. I think it was that one. And it was actually taken on by the party congress of Kokoomus, the coalition party. In 2020, the same autumn, when the law committee handled the FGM initiative, actually quite a few Kokoomus coalition party parliamentarians made a parliamentary proposition on protecting boys. As far as I know, it has not proceeded anywhere yet, but they made it. They formally made it. So they have taken a stand on that. And Svenska Folkpartiet, the Swedish People's Party in Finland, they have tried this issue also in yearly party congress, where a motion was presented, whose approach was more or less the same as the Danish Citizens Initiative, taking a stand for all children, regardless of sex and gender. It was I who personally presented that motion on that party's party congress. It was voted down by 138 votes against 30. This was a few of the political parties, and if any of you who are here or on distance have more information, please mention in the comments if you know what the situation is about other political parties on this topic. And then to end off, we have parliamentary elections coming in April 2023. And if you find this topic to be important, you can always speak to your potential parliamentary election candidate and ask him or her, what is your view on this? Is this something that you would be prepared to work for, to protecting all children? And then in one way or the other, show what they answered also to others who might also be interested in this. This will conclude my presentation. I will take a look and see if we have gotten any questions from online. No particular question there. Some comments for sure, and that's good to see. I will also give you who sit here an opportunity. If there's anything you want to say while we are still on, you can do so. Yeah, go ahead.
Yeah, I would like to ask. My name is Johan Berkevin, and you can't see me, but you can hear me, I hope. I would wonder if you can go back to the Supreme Court decision in 2008.
Yeah, let's see if I can do that. I should be able to.
Or actually, it was the second one coming, second and third one. I think maybe it was 2016. 16, okay.
Yeah.
Because it was so interesting that the man was actually convicted.
Mm-hmm.
In the second case, there is a case 25.
Yeah.
Was he convicted on these two paragraphs that you mentioned earlier, or on what kind of law? Based on which law was he convicted? Do you know that?
This is a very interesting question, and in case it was not possible to get all of it into the microphone, the question was from another Johan who is present here in the audience, on which laws was it based in case 25 2016 by the Supreme Court precedent that the father be sentenced. Now, I am not a legal expert, and I would be very happy. I've also tried to get some more insight into this. So if there is someone who is an expert on this who would want to elaborate on it more, that would be very welcome. So the only thing I can say is that what I see is the criminal conduct and the 2 points in chapter 21, paragraph 5 and paragraph 6. That in connection to what the Supreme Court said itself, that it is not sustainable that we will have to decide this on a case by case, that we do not have any legislation to lean on. I think that is all that I can say about that. But I will go one page further and see again if there's anything more. I would say mainly that they say themselves that it is unsatisfactory. But in addition to the 2 paragraphs in the in the criminal law when it comes to bodily harm. More than that, I cannot say. But let's pass the question on if there's some experts who could elaborate. Do you have a follow-up?
I just a comment on that, because what they actually state as the reason was that there was not a consent from the mother. But
Yeah.
there is no such law that there has to be a consent from the mother in this case. I mean, that would be a very strange paragraph in the legislation saying that if you want to mutilate your child, you have to have the consent of the mother. But there is no such paragraph.
That's true. There is no such paragraph in the law that says that you have to have consent from both parents. But my rather limited insight and knowledge into law, with that rather limited insight, my understanding is that the precedents are then, when the Supreme Court makes a precedent, that one is then used further on. And this was what happened here also. The 2008 case was used as a basis for the 2016 cases. And then the 2016 cases are now like what is ruling, so to say, until we get legislation, which they say that is needed. But you are completely right. There is nothing in the law other than the precedents of the Supreme Court that states this. Yeah. I will check one more time if there's any question among those that are on distance. How much do American politics influence party members voting on this issue? That is actually a very interesting question. We could do perhaps a second session on that where I could elaborate a little bit on it. There was some foreign influence, not necessarily American, or I cannot tell, but foreign influence to some degree in this legislative proceeding for the law committee. But we can get back to that in a second session maybe. Another comment, excellent. It sounds as though there is more discussion in Finland than most of us were aware of. Yeah, it goes up and down. Sometimes there is more discussion. I think there might be more discussion coming now when the work group for the FGM legislation set by the government, when its mandate ends in December and their findings are presented. Then I think maybe some discussion may arise. Was that maybe it? I think that was then it. We will end the session here. We who are present will continue the discussion afterwards. And I believe that the live discussion might not be caught on in the recording, but you will be able to continue commenting in the comment field below this recording, who should turn up right away after we finish it. Thank you very much. Thank you very much.